Okay. All right, guys, I'm back. By now, you should have seen my introduction clip. And I hope that in terms of explaining advocacy a little bit better, out of my personal life and in general, it empowered you with knowledge to your benefit. So what we're going to do in overview now is we're going to jump on immediately. I'm going to tell you about what you're about to do here in this advocacy training pupillage program under Regulation 7 of the regulations promulgated to the Legal Practice Act. A lot of words there. And you're going to get used to talking this kind of language very soon in your career. Well, I remember, quick story, I was sitting with an instructing attorney in a restaurant with a client. And she wanted a restructuring of assets, and it was going to roll out in a divorce. And we were trying to resolve the dispute issues. They had a lot of money, they had a lot of assets, and we were looking at the restructuring, trying to solve the problems. And we did not realize it, but we must have become in our debate of the disputed issues a little bit louder than usually in that restaurant. And people were starting to take note of this legalistic debate of facts and laws and strategies that I was having with the instructing attorney and the client sitting there. Well, we almost sat there for 2 hours debating the issues, finding solutions. And eventually one of the people that was eating there came walking past us and just stopped and said, "May I say something to you?" And we said, "Oh, sure, by all means." He says, "We've been listening to you for over an hour now, and we have no idea what you were saying, but you were speaking English." So that's going to happen to you in the future. It's a legal jargon. It's when you start debating law, there is definitely another language there, a language that even your clients won't understand. So you also have to be careful how you convey information to them. But he was very shocked. He says, "We all speak English, but at some stage we lost you. The words you were using and the terminology, it just didn't make sense at all." But obviously we could see you guys were going at it. And that was interesting. That made me think again about the way we report back to our clients sometimes. And also, let me just move this cursor. What do you call it? A cursor, or whatever you call it. Otherwise, like a fly in my face on the screen. Right, it's gone now. So that's interesting. And you're also going to get to it because, strange enough, when you argue in court, most people don't understand what we're saying to each other. Most people don't understand the submissions we're making to the judge. I had a criminal case which had a bias interlocutory application. And I went into a furious fight. The adjudicator stood us down, the magistrate, and said, "Right, state advocate says I'm biased. 50 minutes, all the arguments." We quickly went out to the wimpy, came back, and we fought a tremendous battle. And later on, the client who was in the accused box said to me, the attorney, I argued against the state advocate. He says, "It was the most aggressive behavior I've ever seen in his whole life. I've never seen something like this." And he did not understand the word I was saying. Luckily, we were successful in coming out on top of that one. And it's interesting. It's interesting that we speak the same language, but within our fraternity, when we do our work and we make our arguments and our submissions, people say we don't have a clue what you are saying. So yes, I suppose that's why we have the degrees and the titles there. Remember, don't put a title first. Put yourself first, title follows. All right, guys, I'm going to start with the overview. First of all, in the overview, I want to draw your attention on the eLeader platform to what is the syllabus content. And the first guide or training manual or guide, whatever we call it, I want to refer you to is the advocacy training guide that was drafted specifically for advocates. And I want to quickly take you through it so that you know what's going on. First of all, let me start off and say to you that during the period of this program training, you will be challenged with 400 multiple choice questions, which has been divided 100 each in 4 assignments. Then you will have 7 practical assignments. Each will count out of 50 marks. The first 25 marks will be theoretical. And of course, the last 25 marks will be practical. You're going to draft, all right? So that's it. We've given it. That's the evaluation foundation. That is the assessment foundation, all right? Now, the reason I'm saying that before I start with explaining and taking you systematically through the curriculum, it's important that I say it to you because I'm going to make remarks about what assignments fits in where to make it easy for you. Because here at LEAD, we totally understand that this is the first ever program of this nature that the LPC has called for. And we understand that this is rolled out most probably the 1st of July, coming Monday, you'll have it. I hope that's going to happen at that date. And before you know it, you're in September, you have to write an admission exam. So at the very beginning, I want to say to you, and you can see now I'm energetic. When I made the introduction, I was relaxed, but now we're busy with work. This is work, and immediately, as an advocate, my demeanor changes. Are you picking that up? It's interesting. This is going to happen to you too. Certain instances, it's going to be relaxed. The moment you work, it's all work and no fun. So it's very important to relay this to you, tell you that to make it, to help you go forward, to say these assignments pertain to that work and these assignments pertain to this work. Otherwise, you know, we're going to be talking about something like a reading list, which you have already seen, haven't you? You saw it, right? That is where the LPC said, right, this is going forward, and you saw the reading list there. Some pupils has already contacted me, and the one thing I said to the pupils is, start reading that reading list now. That was about a week or 2 ago when it came out. Said, start reading that reading list. And I want to go through that reading list with you also. It's important that we show you what's going on here and take you through everything. All right. Now, in the pupil guide, when you go to the index, and that's where I want to start, there's a welcome again and the purpose. And then, of course, why the subject matter is important. Let me just stand still there for a second. The whole idea between this, although there's a lot of theoretical questions because it's online, it's distance learning. What can we do about it? The world is changing. It's important that even though that is the case, you will see that through the 10 practical exams, the emphasis is practical drafting. Drafting. That's the one thing an advocate cannot get away from. As soon as possible, an advocate must attain the skill of drafting, because that's the one thing he's going to be instructed on right through his career. On multiple occasions, and that's where he's going to make most of his money, the drafting, and then of course appearing in court. So it's important to say this to you, that you understand that we are trying to equip you in a short period of time to pass your admission exams, because if you work through this, listen to what I'm saying, if you work through this, then your admission exams, you will approach that much more confidently. This will assist you, because you'll see the LPC is saying that your exams are coming out of the reading list. This will assist you to look at what the practical questions are going to be and the theoretical questions are going to be. If you work through this, listen to me, every assignment, every single one, to the level of a competent pass mark that is above 50% at all times, you will have more confidence. You'll know what's going on. And most probably, and hopefully, you will have success in admission exams. It's important for us to prepare you, at least on this foundation. If you are a slacker and you're going to play around with this, don't come back crying. You're becoming an advocate. The exams are much more severe in the time periods than with attorney admission exams. Has always been there. All the years when you go to the chambers, it's been the same. You write a whole week, you're 8 hours locked into a library, and they give you certain aisles, so you might just work out of that aisles, and for 8 hours, you're sitting there, and the people flunk. Hopefully, this has been restructured in such a method that we don't have something like that, and we believe that all of you will be successful. But I'm stern. I'm saying, muck around with this, and you will not pass. Don't work systematically through what we are giving you here. You will not pass. Don't reading that reading list as soon as you get this clipping, or some of the pupils that contacted me, I've said start reading again, and you'll be in trouble. You have to work hard to be able to pass the admission exams. And then from there on, it becomes a little bit easier to get where you're going. Again, I'm reiterating. While you're doing this training, get out to a chamber, get accepted, show them that you've enrolled here so that your application can be viewed in a more favorable approach. And see if you can get in there so that you can do that period of time with your supervisor. That all of this comes together. This in any event is a skills development course. This is to develop your skill and get you to where you are going. All right, enough of that. Learning assumed to be in place. We assume you have your law degree. We assume some of you have been busy with some kind of legal substance out there, and we assume all of those things are right. This is distance learning. You not sitting in a classroom here where we are seeing you every day and merely looking at your face, I can see that nobody is home and I can assist you. We don't have that luxury here. And you are the first pioneers. Congratulations, by the way. You are the first pioneers that's doing this. And therefore, we also want you to be successful. By the way, we are going to be meeting with you online through the months you're going to be enrolled on this. And there we will answer some of your questions. Not administrative questions, not logistical questions, questions pertaining to the work, especially the practical drafting work. Because the way these assignments are going to operate, the practical ones, is you'll do the assignment, you'll submit it before the date, and then the memorandum will become available, and that's how it's going to operate. And then later on, you're going to have the opportunity to say to me, well, I didn't do it precisely like that. I did it like this. What do you think? And I'll say, no, but that's fine. Or no, don't do it like this. Rather stuck with what we set out in the memorandums for you. So there is going to be a couple of times, and they will be announced. They will be available on this platform where I'm going to come in. So far, it's me, but it could be anybody. And we're going to accost you, and we'll see where that goes. So you're not going to be alone. Now, in the same sense, your logistical and administrative queries has to go to the coordinators. You cannot look at us for that. We're also contractors with this institution, and we always contribute here. So please, you cannot burden us with this. You burden us with the program, the content, and moving you forward, and empowering in your knowledge, assisting you, and other things must go to lead itself. The learning outcomes is in there. I'm not going to go through there, but you can have a look at that there. That will tell you what we expect of you, what we think you should arrive at when this is all done and dusted, if I may say that. Pupil support before, during, and after subject-specific training. Actually, I've now spoken about it. I have spoken about that. And time management. We have something in there in time management. Have a look at it, but I want to talk about time management on my own. You don't have time. The moment you see my face and my words and my head bopping up and down, you don't have time. You must start immediately. And I recommend you do all the multi-choice immediately. Because if you do the multi-choice immediately, you're going to assess yourself in a grade in terms of competence. Are you competent? Are you competent not? And the multi-choice questions, most of them are in the reading list, and they will empower you when addressing the practical assignments. They have a level of competency, they have a level of information that's really going to help you, and you will only be allowed to do it in a certain period of time. And that's also why we're going to tell you what multi-choice questions fits where. Because if we don't tell you that and you take all 4 multi-choice questions and you want to do them through the reading list, you're going to sit day and night and get nowhere. So we will assist you with that. Time management is of the essence. Stop the socializing. You need to get to September. You need to do these exams. This is not a joke. You've paid some money here. Everybody is looking at you, your family, your own expectations and your own dreams. You need to now calm down and apply your mind for the following months and get down to doing this. If you don't do this, you're going to be unhappy. And then, if you're not going to do this, why did you enroll? Remember what I said under introduction. We are already creating a platform to show you how disciplined the advocate must be. This is the same as you working until 3 o'clock in the morning and 6 o'clock you're up again and going to court. This is it. Pressure, pressure, pressure. advocates are always under pressure. Most attorneys phone and say, afternoon, can you be in the court? And you haven't read the word, you don't know what it's about, and it's happening in real time. That's advocates. Attorneys are not under that pressure, and they like passing the buck. You will find if you become an advocate that if they have to get up 3 o'clock in the morning to quickly go to the police station to assist somebody because he was caught under the influence, do you think they get out of bed? They pay you the big bucks. They phone you 3 o'clock in the morning and send you to the police station. That's advocates. That's what you're getting into. And you got to start here now. All right, guys. A little bit stern there. All right. Don't let me take my belt off for you. Okay, that's unconstitutional nowadays. Won't happen. All right, let's go on. Syllabus, Legal Practice Act. I'm looking at the index. Most probably you have it in front of you. Or you're listening to me, you can look at it later, doesn't really matter. And you'll see there, I'm just going to go through it quickly. In this guide, very important, we are telling you what the advocate is all about. And at the same time, while we're telling you what the advocate is all about, we're also telling you what the legal practitioner is all about. Because when you read the Act, some of the sections are specifically for advocates, only advocates, and some are for legal practitioners in general, but that swallows up advocates. Now, I'm going to say this now because I didn't say it in the introduction. This program has got nothing to do with Fidelity Fund certificate advocates. Actually, I think I did touch on that in introduction. Is that correct? I think I did say something about it. You are not doing bookkeeping here. You are not doing firm practice management here. We're not doing that. This is only your normal advocates. If you want to become a Fidelity Fund certificate advocate, you have to register for those additional subjects, and you can also do that with LEAD, but it's not through this program. Please take note of it. If you read your brochure, then you will see we make a very stern point about two things there. This is not trust-bearing advocacy, and we also talk about the fact there that you must still enroll under your supervisor to become an advocate. There's no misunderstandings here. There's no misrepresentation here. We are clear on that. All right, let's go on. There you'll see we deal with normal advocates, Fidelity Fund advocates. We teach you what that is because you might want to become that. Advocates in general. And we also touch a little bit on state advocates. If you want to know more about state advocates, you can actually go and read the State Attorneys Act, if I'm not mistaken, because state attorney, state advocate, basically the same thing. So we take you through it and we show you what's going on there. Regulation of legal practitioners and candidate legal practitioners, we take you through that. It is important for us that you understand what this is all about. And let me clarify one thing now. I'm not lecturing. I shouldn't do that. Remember, we are all now what? Let's get us out of the way. We all what? We legal practitioners. And after we are legal practitioners, we are either an attorney. An attorney can be subdivided in a normal attorney, a notary attorney, a conveyancing attorney. Or you're an advocate, and that can be subdivided, a normal advocate, or an advocate, trust-bearing account Fidelity Fund certificate advocate. You are a candidate legal practitioner. Do you understand what I'm saying? You're first a legal practitioner before anything else. That is why your application to court is twofold. You apply to the court to become a legal practitioner, and then the second application in the same application or an independent application will be, are you going to be attorney, advocate, or whatever? You're also a candidate legal practitioner. And a candidate legal practitioner rolls out into a candidate attorney or a pupil. You, my futuristic respected colleagues, are pupils. But you're first a candidate legal practitioner before you're a pupil. All right, so that's important. Let's just get these terminologies correct because everybody's confused by them. All right, and then we take you through the Legal Practitioners Fidelity Fund. We teach you about these things because a lot of you are going to register for the subjects at the same time, or a lot of you are going to decide later on to become trust-bearing account advocates. So we teach you now, we go through it, we show you. Although this program does not make you a Fidelity Fund certificate advocate, by no means, we don't do those subjects. Legal Practitioners Fidelity Fund, again, we look at them. There's a couple of sections you know about. Handling of trust monies, we're going to talk about that. It's imperative that you know it. Now, you will most probably ask, but why do you put so much emphasis on trust account advocates if this is normal advocacy? Well, the answer is logical. What is the answer? I challenge you. What is the answer? Yes, it is indeed a fact that you're going to do litigation on this. You need to know how this operates. You're going to defend your colleagues at disciplinary hearings in criminal court and civil court. You need to know this because an attorney of record will have an advocate client that's in trouble and appoint you as the advocate to represent him. That's why you need to know these things. And of course, we have a serious problem. If you go and look at the LPIIF stats on trust account money getting lost by attorney firms, sure, I don't know how many RDP houses we can build with that money. It's horrendous. So that's also why we're teaching this. As an advocate in law, you must know as much as possible, and you must come to know it after you've become an advocate as soon as possible. Because your mere title renders other people to put faith and trust in your abilities, and therefore you've got to excel yourself. Right, we're going to talk about the general provisions, the national forum and traditional provisions. We talk a little bit in chapter 10 about that. And then we're going to apply our minds to definitions. In this guide, we're going to show you specific definitions. And it's important that you look at those definitions, because when you make, for example, an application to become a legal practitioner and then an advocate in this instance, some of those definitions are very important. Otherwise, you might select the wrong sections, regulations, and rules, and the court might throw your application out. On a note on that, it's alarming. We discussed it the other day here at Lead, how many of these applications are unsuccessful. They become a legal practitioner and an advocate or an attorney because they are not correctly set up. So there, we're going to take you through all of that. Then again, there in 5 certain definitions under Section 1 of the Act, Section 29, we take you for all those definitions, and we are going to talk to you about all those sections. And then we have a short teaching, if I might call it that, the relationship between attorneys and advocates. That's very important. Remember, attorneys is going to be your clients. So we need to know where advocate stands, where attorney stands, and how their relationship should be governed. And the code of conduct also tells you a lot about that. But I want to come in here. I've always been a team player. And I used to cut attorneys and not work with them anymore. I like the attorney, especially in criminal court, that sits right beside me. And while I'm cross-examining, he's putting a slip under my nose. And I would say, don't worry, I'm coming to that question. I'm catching him. Or I would say, no, this is good. I was going to forget about it. I'm a team player. You're not more important than an attorney. Please get that out of your head. There are senior attorneys that knows much more than advocates. Believe me. All right. So we deal with that relationship. But that relationship is going to be the success of your practice, your advocacy career. There's attorneys of record giving you instructions. And so we talk a little bit about that and how that goes down. And obviously, we're going to talk about the fees and the mandates and all of those things. So, yes, that's important. Professional conduct and legal ethics of advocates. I'm going to do a course on the people one. You'll get a clip. If I say tomorrow, that means nothing to you. So there'll be a clip about that. But the code of conduct, the BAR's code of conduct, the LPC code of conduct, the people code of conduct. There's so many code of conducts for advocates out there. The one is a general one for legal practitioners. And then, of course, the specified ones for advocates. Ladies and gentlemen, I've been shocked in my career that when you talk to my colleagues and say, when last did you read a code of conduct? Most would say, I've never read it. I just go with the flow. Ask my colleagues, what should I do? And that's how I do this. Guys, the code of conduct now under the new Legal Practice Act and regulations and all of that is severe. You cannot do that. You can get in so much trouble, and just because you didn't read your own code of conduct. So there is 2 code of conducts you must read. If you become an advocate. It's a legal practitioner's code of conduct by the LPC, and it is the Bar Association you're going to join, their code of conduct. I will, in a clip, I'm going to go through the curriculum code of conduct, tailor-made for pupils, and then we can deal with that. Do you see there? You cannot hear it. There you go. My phone is ringing. Another attorney. And that it is for advocates. There I can see it on my screen. Work is coming in. That's great. That's what advocates do. It's always pleasant when you see your phone ringing and you know it's an attorney. and work is coming in. So that's practical. I can look at it. I'm looking at screen and I can see that the attorney is phoning me. All right, let's go on. So in short, what does an advocate do? We're going to teach you a little bit about what the advocates do, but I've already kind of told you. Just to make it clear, you do a lot of legal research, a lot of drafting, a lot of going to court, and you do a lot of legal opinions. Another place where I built myself out and made quite a lot of money was negotiating and securing clients. There's a couple of attorneys in the city that came to know that if I'm in the board meeting, whether I'm going to get a case instruction or not, they want me in the first meeting because I have developed the ability, not because I'm clever, because of experience, not because I'm clever, by no means. Through experience and experience gaining confidence to sit in a board meeting, listen to corporate clients, and with half an hour say, this is how I see, this is where it's going to go, and I think you should do this to start a process. And I like that aggressive attitude, and they're happy with me. Therefore, the attorney gets the client. That does not mean I was going to run it out in litigation, but that's also negotiation skills. I will also used to do mediation. So those are all things that you can enroll in, and you can make yourself better. As an advocate, I believe it in my heart, you must be a general practitioner advocate, because you can still specialize. But if you only specialize, you might not always get a work in. Liability insurance for legal practitioners, we talk a lot about that. The LPIIF and everything that's now available for advocates also. So those are things that you're going to have a look at. And very important in this specific guide, I'm only talking about one guide here now. We're going to roll out into something else in a moment or two, but I'm only talking about one guide here. We've got some annexes there, and the annexes are very important, and please listen to what I'm saying. Your multi-choice questions and your practical exams has been based on the annexes too. I've picked up an interesting, I call it anomaly. Anomaly is the wrong word, but I'm going to call it anomaly because I want to. People don't read annexes to training guides. Yeah, you. And I don't know why. So what we have done, we are testing you on the annexes to why. You'll see the annexes here has got code of conducts here. You need to know this stuff. You need to know what the LPIIF can cover you for. If you don't, how do you know if you got into trouble? I've met a lot of attorneys that says, we went bankrupt, problems, trust account, we're out. And I say, did you put a claim in here? Did you put a claim in there? They say, no, but I don't know that cover. I say, sometimes you have it for free. Go and read a policy of the LPIIF. So guys, this is very important. You have to read. As you are listening to me, I've told you, read the reading list. You know what you do while you're reading the reading list? Because it's difficult to read the reading list. I'll go through with you in a couple of minutes. You read this book first and its annexes. You go through everything we give you. All right. There is other source material on there. I'm going to talk about it. And I advise that when you go to that source material, that you only go there when you are challenged with a question, a practical question. And if you have time over, which I doubt, after you've done all these assignments, read the reading list, read this guide in preparation of the admission exams in September this year, then you can go and read them. Otherwise, you just use them for what we call them, source documents. Right, there's the admission of advocates, and well, actually Annex A here on my list, Fidelity and Fund Certificate Application Portal. We show you how to go there. Admission of advocates is that old act. You still need to go and look at that act. There's a court case in your guide you have to study. You might be doing this course, but maybe you still fall into that time periods. It was the Goosen court case. You're going to have to look at that. That's why the Admission of Advocates Act is still relevant, but shortly it won't be anymore. It will be repealed in totality. There is the adjustment of Goosen's application. We've given you the whole court case there. Practical vocational training contract. There it is. Do you see? We are giving you all the tools to become successful in being an advocate. So that's your contract you have to sign. We've given you one, very short, and that's the one you can use. There's the General Council of Bar of South Africa, Uniform Rules of Professional Conduct. That is the overall bar one. That's kind of an important one for advocates, where the Legal Practitioners Code of Conduct is for everybody. And in their document, they break it up, advocates, attorneys, blah, blah, blah. So you've got to look at that. You've got to go through that. There's the certificate in terms of section 25. What is that? What is that? What certificate is 25? Go look at it. If I can give you a clue, most probably a right of appearance. There you have Ethics 2020 National Curriculum. That's the one I will be dealing with you tomorrow in a clip or the day after. Not that tomorrow means anything new, but in the third clip we'll be doing. Then we have a list of banks that have entered into banking arrangements. I'm not even going to read further, because if you become an advocate, sometimes you read half a sentence, you know where it's going. These are the banks where you can open trust accounts. All right, there we go. And we've given it to you. Because if you open up your advocacy practice with a Fidelity Fund certificate, then this becomes relevant. And you need to know it. Maybe in the future you want to convert over. You never know. And then also we gave to you the notice of the LPC law library. Now this is very important for me. You have to register here. There is a library available to you for free. And you've got to see how you can register. Here, I'm not too sure how that's going to operate in terms of your membership number. So that's something that maybe you can write a letter to the administrative division and say if you actually can. But if you cannot, it's in here, so you can do it when you have enrolled and you've got an LPC membership number. You are an advocate or whatever the situation is. But a place where you can enroll, if I'm not mistaken, is the KwaZulu-Natal Library. I'm now in the process of doing it. It takes a while. Your application lays there. They said 48 hours. I think I'm over that. But that's a very good library. You have access. And I'm sure that you'll be successful there, because they did not ask me my membership number. So I was surprised by that. Everybody said they were going to do it. But when I applied, I saw they said nowhere a membership number. So you might be able to do it there. And do it so that why? I'm getting to the reading list. And I'm concerned about the reading list. So if you are joined by one of these libraries and you don't have to Google everything on the internet, it's going to be so much easier. And that's my concern. It's a massive reading list. So we have to look at that. Please take this advice seriously. There you have a template for admission of the application to the High Court. Ladies and gentlemen, we've given you the guidelines. We've given you an example. And in one of your practical exams, this is a question. In that specific exam, it's one of the first three of the practical exams, 1, 2, or 3, not a multi-choice, the practical exams. Listen, you have to do this with your personal correct information. Your correct information. You are Linda Matabula. The reason we're doing this is so that you can now put up your application. And when you are finished and you've done this course and you're finished with your supervisor, you know precisely how to do this. They are rejecting these applications left, right, and center. So we're giving you instruction, and we're instructed to use your own details. And you can project it. You can, for example, say, yes, I am finished with the PVT training. Yes, I have passed my admission exams, and I'm attaching the certificates and whatever the situation might be. You must put up that application as though you're prepared to bring it to court with your own correct details. This is a very important exercise. I had attorneys phoning me the other day, pupils, who says, we want to do this thing. Where do we get this here? Where do we do this? So we're teaching you. We're giving you instruction to draft it. And then later on, with those 3 or 4 feedback sessions I or somebody else going to have with you, you can ask questions on it after you've done it. So this is very important. There's the first 3 of the practicals. And there we have the template, and we have the example. We have example out of Cape Town for you. You have to do it better. You have to do it better. I'm not in the least impressed with that example. Your language, everything, your structure, everything, you have to do it better. Tell your story. Make certain that the court does not say no. Then we have the code of conduct for all illegal practitioners, candidate legal practitioners, and juristic entities. And that is the last annexure. That would be Annexure L to the pupil guide we have set up for you. All right, ladies and gentlemen, that is the first little one down. And I advise, let's change it. I advise you read this first, because you can read this in a day or 2. If you sit a whole day or 2, maybe a third day, you're finished. In your heart, you are finished, you're relaxed, you tackle the reading list. All right. So let's quickly have a look at the program. I just want to have a look at the program. This is the program most probably on your e-leader platform, and it's subject to change. I think we've already changed a few things here in any event. I just quickly want to go through this very quickly. There's a 21 total program hours, and it amounts to 400 notional hours. I actually think it's more. So let's have a quick look here. We have an overview and introduction. I already did an introduction. You are sitting, if you're listening to my voice now, to the overview. We have introduction to research, business and opinion writing. That material will be loaded. And please, legal research and opinion writing and drafting is paramount. It's paramount. You will be tested in September on these things, especially drafting skills. Can't get away from it. And of course, theoretical will be there. And hopefully we have managed that through the reading list adequately for you. We don't know what's in the exam. Let me make a point here. I have no idea what's in the exam. That's been put up by independent people, and we are not privy to that information, which I agree with, because it might constitute a kind of a conflict of interest. Oh, do you listen to the language? Are you picking up the same language you're going to be speaking in the future? Alternative dispute resolution is one of the things we have loaded up there. Civil procedure, including high court and magistrate court practice. This is very important. When you read civil procedure, including high court and magistrate court practice, that's drafting. Don't be confused. That's the rules of the court by drafting. There we teach you how to draft them, application procedures, action procedures, particulars of claim, under the application, affidavits, all of those things. We teach you there to draft a lot of things, and thus that is very important. Constitutional litigation practice is one of the Regulation 7 compulsory subjects that you have to complete. Criminal court practice is also one of them. Advanced drafting of contracts. Now, in terms of advanced drafting of contracts, I have material that on webinars I've done in the past, but I'm doing next week, and you won't necessarily know what next week means. But you'll find 3 sessions on there where I'm doing advanced drafting of contracts, and you can have a look at that and see what I teach you. Labor dispute resolution, we've thrown in the legal costs, is very important. And then, of course, professional legal ethics for attorneys and advocates is also on there. And yet again, back where? Where are we back now? Code of conduct. Code of conduct. Go and look at my introduction clip. I spoke to you about behavior and all of those things. You're in the public eye. Attorneys look up to you, and they will. Just because of the title, they will forever. I don't know how the country is going to change in terms of this, but for some reason we are put on a pedestal, which is not a good thing. We should not be in a pedestal, because when you fall off, you fall much harder than the people that's not on it. Cyber law is a requirement, so you'll be getting, we're busy with that. In the week I'm speaking, we have somebody working on that. It's soon coming to me through Lead, and we'll make certain that's of high quality, and that will be on the eLeader platform. That's a requirement. You can get all of these things, you can get questions, practicals. And then, of course, personal injury claims. Just take note on personal injury claims. I know I'm not lecturing here, but there's another new letter that came out from the LPC a day or two ago on this. So please monitor the LPC notices, which you most probably are not getting. So talk to an attorney or an advocate to make those available to you so that you can see what's happening there. A lot of changes there. Matrimonial matters and divorce. And then, of course, customary law. Well, actually, it's customary law they're busy with this week. I think cyber law, we are good to go. So it's actually customary law in the time I'm speaking to you. Not necessarily that you would relate to the time, but that's customary law. And a lot of your assignment questions, multi-choice questions, came out of customary law. I made a note of building it in there. That is the overall program. Now, when you page through this overall program, and I believe this will be loaded, let me just quickly inquire. I'm not alone here. I've got Mrs. Tasha Rustov here. She's the Quality and Assurance Manager of Lead. Let me just ask where I'm sitting. I'm asking. This is going to be loaded. She is nodding. She says you'll get us. And when you get us, then you can go into the detail of it. But I want to go through the detail with you because I want to calm you down. I want to calm you down, but I want to freak you out also, because time is of the essence. Yeah, difficult to understand that inconsistency, that 2 versions of 1 sentence. All right, when we go to page to the second page, then after this overview, you'll see there they have the guide there. I'm not going to talk about it except to say that that guide was specifically drafted on the Legal Practice Act specifically, and I incorporated all the rules and the regulations also in there. So that's very important to bring under your attention. Before I forget, I don't think I'm going to forget. Also very important is the drafting skills booklet from Judge Hussain. That's also very important. That's also a book that I think you must really go through, work hard through it, going up into the exams, so that you know what to expect. So when we go to that's overview introduction. So in the introductions to the research, business, and opinion writing, you'll see there we have legal opinion writing, foundation, introduction, taking of instructions. That's very important. And then we have Utastat worksheets there. They call it research methodology. Can't pronounce that right as an Afrikaans speaking person. In any event, they've got the revision worksheets there, etc. Computerized legal research revision worksheets, and that's the way it's going through there. It might not necessarily mean anything to you now, but it gives you an expectation of how expand and how big this program is. Alternative dispute resolution, they break it down for your online subject as online the Brownlee judgment. The Brownlee judgment. Now remember, I set up your assignments. I'm only going to say, the Brownlee judgment, and I'm going to move on. Rule 41A, and I ain't going to say nothing more. Remember, I did not set up the exam, so it's all good. I'm not doing anything wrong. And then I've got video clips there. All right. So remember the R's. They're going to be to your favor. They've got a video clip on arbitration there. They've got a video clip on mediation. So it's not that you're going to be reading a lot. You're going to be looking at a lot of video clips and recordings too. Then when we move on to the very important one, civil procedure, including High Court and Magistrates Court practice, because we are looking at uniformity between attorneys and advocates. We already know that in the last few years, due to the amendments of the rules of court, we are bringing the High Court and the lower courts and all the courts rules together, that they kind of read the same thing. And that's why magistrate and High Court practice in the future, I believe, is going to be run out only as civil procedure. I'm going to say this again. Here, drafting is paramount. Here we teach you those things. Okay, moving on. I've already said it. Also on the civil procedure, what are we doing? The High Court practice, Magistrate Court practice, litigation techniques. Very important one. Streetwise and independent thinking, litigation techniques. I've won cases in the most weird ways imaginable. Constitutional Courts, Magistrates Court Act, National Credit Act, very important one there. Superior Courts Act, and please, ladies and gentlemen, the Supreme Court Act and the Superior Court Act has two different acts and two different court jurisdictions. For some reason, people think if we say Supreme Court Act, we mean Superior Court Act too. Not the same thing, please. General applications, application procedures, they have that in there. Bilateral applications, and then they have under urgent applications a great amount of audio clips. That is very important. They have under consultation, representation, demand, and prescription. They have a lot of clips there, and I want you guys to really look at prescription. Prescription runs, I'm going to say it, I know I'm not supposed to lecture. Prescription runs from the date of your knowledge of damages. That's all I'm going to say. Don't come with stupid ideas of dates of signature and I don't know what else. Go read the Prescription Act. Is the date of, and how do I know that? I used to specialize in medical negligence. 10 years later, there's a twitch. Goes to a medical, I'm lecturing, but okay. Goes to a medical expert and he says, did you have an operation 10 years ago? Yeah, that doctor cut me. And he says, well, he was negligent. That's the date your prescription start to run, not when the quack cut you. Got it? It's from the date you have knowledge of your damages. Man, that was one of the first cases I ever fought and won, and that's why I'll never forget it. All right, I've got the forms there, all official jurisdiction, audio clips, general principles. It doesn't say a lot. And then jurisdiction of your High Court. They've got a lot of clips there. Jurisdiction is very important. It can sometimes be difficult. We talk about concurrent jurisdictions, etc., areas, districts. So it can be a daunting situation. You need to know how that works. Got a lot of audio clips there. You got to look at all of them. Actually, I think I advise 2 hours sleep a night. So you've got 22. Surface of process. There's a lot of audio clips there. Surface of process is very important. You can be tested on this because that's where a lot of litigators make their mistakes. They got to do condemnations or they're out of time or whatever the situation is. Very important. Summons, particulars of claim and declaration. Now you would remember I said applications. This is action. Very important. I tell you now, if you are not tested on a POC, I will be surprised. Then the parties, the citation of the different parties, natural persons, trustees, juristic persons, that's always important. And then again, they go there on page 8 and they talk about practical drafting. And again, that is where your marks are going to be. You need, as an advocate, a practicing advocate must be able to draft. I remember the reason I specialize in medical negligence, the same as contracts, is my junior master called me into her office the first time ever I've been in advocate chambers. Never been there before in my life. I don't know what the hell is going on. And she says, right, I'm going to test you. There's a pen and paper. Set up a POC for medical negligence. Here's the facts. And they are going out drinking and socializing. She and a female colleague advocate, and they come back late in the afternoon, a little bit happy. And they look at my work and they burst out laughing. I was so embarrassed. And later on, I took that negative and I made it a positive. I used to put up medical negligence POCs over 60, 100 pages. I used to challenge medical professors and they used to accept my version of medical issues when I challenged them on it. I took a negative. I took something that shot me down and embarrassed me and I turned it into a positive. Why am I keep on saying this? Being an advocate is challenging because you get insulted and embarrassed the whole time from the bench in a high court. That's just the culture. So that's important for me to say that to you. You need to be an overcomer. You need to be an overcomer, and you need to be able sometimes to suck it up and get over it. So when there's a negative, make it a super positive. All right. Then they go on page 8 to constitutional litigation practice. This is something important. A lot of emphasis are placed on litigation in the Constitutional Court. In the past, I used to teach you Rule 18 and all of those things, direct access, amicus curiae, all of those things. But they're really trying to teach you now the litigation skills in the Constitutional Court. And that's important that you understand that. Might get a question on it. I don't know. I'm not involved on that side of this training program. Criminal court practice, please, ladies and gentlemen. All right, I was a police officer years ago, so maybe that's why I like the criminal court. I've always felt comfortable there, falling under the building rubble, wrestling with the unpleasant prosecutors and magistrates. Nobody's ever happy. Everybody's grumpy, and I excelled. But that's maybe because that's where I landed. If you are hearing a beep, 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 it's not your watch, it's my 12 o'clock or 1 o'clock watch, don't worry about it. So, criminal procedure, get in there. Go and do it. Don't be intimidated. It is my personal opinion that it's much easier than civil litigation. I'm telling you straightforward. I used to do murder cases. I'm good on fraud cases. Always used to go up against SARS. And I really enjoyed it. I really enjoyed it. Okay, it's hurry up and sit because you wait. But sometimes they give you an independent court if the trial starts to run. And some of my trials ran over 3-4 years before they ended. That's a good income. Do not be intimidated by rudeness, unpleasantness, and Criminal Procedure Act. The Criminal Procedure Act is very easy to understand. And nowadays, you can get a template for anything. So that's very important there. Please go and have a look at that. And then advanced drafting of contracts. I'm going to be talking about of contracts then. Hopefully, I'm going to talk about all of them here. But if not, the basic contract drafting skill is an easy one. And this is a good income basis for advocates. I don't know as an advocate how many contracts I have drafted. There must be thousands. And this is something you need to know. And all of this drafting skills comes together in a general expertise of drafting that you will obtain through your career. You can see the acknowledgement of debt, shareholders agreements, business agreements, suretyships, all of those things. So you've got to familiarize yourself with that. Then on page 10, they talk about labor dispute resolution, and they talk there about CCMA and all the acts, the BCA, the Employment Equity Act. Everybody always knows what the Labor Relations Act and the Basic Conditions of Employment Act is, but you very rarely hear people talk about the Employment Equity Act. And we have a equality court. So at the end of the day, that's important so that you can have a look at that. They talk about the National Minimum Wage Act, that you know there's a thing like that, and all of those things. Mine Health and Safety Act, and you need to go through all of that. Unemployment Insurance Act, but I think with COVID, everybody knows about the UIF Fund Employment Act. I think that was one fund that paid a lot of money out during COVID. I still do. Legal costs is very important. A lot of people really understand legal cost. I'd like to do something on that in the future, explain that. And then, of course, code of conduct and a professional ethics, code of conduct, and a lot of videos there. They go on page 11 and they break down cyber law. Ladies and gentlemen, the approach to cyber law, don't be shocked. Don't be shocked. The approach to cyber law is a more technical approach than a legalistic approach. I was surprised myself by it. And then what I did is I went and I looked at it and I thought the material was very good. And some of my colleagues, advocates, have set that up. So this is also something that's now deserving a lot of attention. So as an advocate, you're going to get a lot of work on it. I just finalized a fraud investigation over 2,000 pages long where cyber law and the electronic communications and electronic transactions was paramount. Paramount. The whole thing was about cyber law. And that's why we had to submit a 2,000-page criminal investigation to the SAPS. They talk about, they got introduction, activity, cyber law assessment. How do you time your instinct of curiosity and trust? Assessments, hack, attack, cyber law stuff, and they also end where they with summative assessments. So this is something you're going to have to look at because I touch on this in assignments. In the multi-choice assignment, there's a lot of it. And in the other 7 last practical assignments, I'm coming back to this. Insolvency law is always good because it teaches your drafting skills. And there's a specific way to do it. And this is actually a very good guide. And the insolvency law, the sequestration and liquidation, sequestration of natural persons, the liquidation of juristic persons, and sometimes with a trust, because under certain acts, a trust is either a natural person or a juristic person. You will then also attach a approach it in that manner. So this is something you can look at. This is a good drafting skill. And I think one of the 7 assignments, I might put one in there so that you can draft something like that for us. This is a very good. I like to do sequestration and liquidation applications because that's how you start as an advocate. How do you, how do you start as an advocate? Unopposed divorces and sequestration litigation applications. That's it. That's where I started as a junior counsel. You get a lot of them, and that's how you build confidence in the motion court. All right, so that's important there. And then, of course, they took you through all of that there, and they come up down to personal injury claims. That's the RAF, but you look at a lot of acts there. You're going to go through that. Road accident fund activities, PRASA. Unlawful assault and arrest activity. I just want to say something. I've picked up the misconception about personal injury claims. Let's talk about that. Let's talk about that a little bit. It's not only RAF claims. It's not only RAF claims. It's all kinds of assault. It's all kinds of injuries. People also think, oh, personal injury claim, we're going to deal with road accident fund. Nonsense. Go and look there. There's 3-4 different divisions of injuries you can sustain. That has got nothing at all to do with road accident fund. So, yeah, did you know that? It's not only about that. That's your personal injury claims. And then matrimonial matters and divorce. Take this one serious, ladies and gentlemen. I might test you on this in the assignments. Again, I've got nothing to do with the exams. The LPC does it. This is the LSSA lead. All right. So go look at matrimonial matters and divorce. It's imperative. This is where you're going to make money as a junior. This is one way you can do it. And I'm going to say it now. I'm going to say it. Are you listening? Everything you do, here it comes. Rule 49A, capital A. I'm not going to say anything more. I'm not going to say anything more. So you need to understand what that is all about. All right, guys, I'm going to move over now to the reading list. That is then the program. That's actually the whole program. Am I correct, Mrs. Rustov? That's the total program. She's not speaking. She's nodding her head. All right, but she's got the angel voice. She just don't want to use it today. All right, here we go. Now, the reading list is intimidating. And it should be for advocates. I totally agree with it. You're not getting away. Advocates has been trained by official bars for years in a specific manner. And I might not always have agreed with the training because of the specialized skills of the lecturers. But I believe the content was always right. I just don't believe the guys they selected to come and talk to us knew what they were talking about. There was that most certainly did, but I remember one day, and I won't call the bar, except if you Google me, but I don't think under the new legislation you'll be able to see. One of the senior advocates walks in and he was supposed to lecture. And he says to us, well, I have been asked to come down here. I don't really know what I must do here. Do you have any questions? And he flipped through the file like this. I was sitting behind a pillar and I thought, wow, I'm becoming an advocate. And what kind of example is this advocate, senior advocate, setting for me? But then I left that association, went to a rebel bar. And before they were finished, I was doing cases. And one day he was in the same court as me, and I saw how he attended to the case, and I understood. I totally understood, and let's leave it at that. An advocate must be disciplined, do the work to the best of his ability, know what he's getting himself in, and always be able to measure and balance the confidence he's instilling in terms of the standard of service delivery. Big mouth advocate that says nothing is worth nothing. But an advocate that has the right characteristics and knowledge, that's a dangerous weapon for his client. And that's who we are. We are weapons, and we dare to look after the legal interest of justice. Something we can talk about in code of conduct. But in code of conduct, sometimes you have to act to the detriment of your own client. If you have information, you have to relate to the court. We're going to have to look at things like that. Because when I became an advocate, all the advocates did it. They were good with it. Nowadays, I see ugly business. They try to get those orders through without informing the court about things they should be informing the court to the detriment of their own clients. That's misconduct. We're going to have to talk about that when I come back here on conducts. Right, code of conduct. Okay. What I have done with the reading list is I have divided it into 5 reading lists, because there are actually 5 independent reading lists. And the first one I'm going to deal with, how will we identify this? Okay, the first reading list I'm going to deal with, Mrs. Rustov, is maybe important that we file them in sequence. If they are following my voice and what I'm saying about this, then this is how they fall. Now, the first one is the one that starts under norms and standards. It says the following: published in a Government Gazette 43981 on the 2nd December 2020 under section 3G1, read with section 6(1)(b) I and section 995 1N on the Legal Practice Act of 2014, and I will hand them. When I'm finished with them, I'll hand them in sequence to Mrs. Rustov, because she is making notes while I'm talking here. So that's the first one. So we're going to deal with that. There they say your principal works to be used here is Erasmus Superior Court Practice Volume 2. And they say the additional reference works here is Jones and Buckle, Civil Practice of Magistrates, Court in South Africa, Volume 1 and 2, Jones. Now, you will see it's got 2 divisions, norms and standards and reading list. Now, the reading list can be wide. Are you listening? For example, the reading list may say a court case, but if you correlate it to the norms and standards, you will see that it addresses a specific division within that court case. So you don't have to read that whole court case the whole time. You'll see a lot of court cases. You have to read the whole court case, but a lot of court cases, they mention the paragraphs. Then you must just read around those paragraphs to get an understanding of what I want to bring home. So when you look under the heading reading list, correlate it with the norms and standards. For example, here on page 1, and we're going to go fast through this. Compulsory reading material, they say the ethics of a hopeless case by Owen Rogers, and then they say specifically pages 50 and 51, where Owen Rogers goes and it gives a summary. Remember, you don't have time, you're up in September, it's war. So you need to follow these guidelines. And if you don't apply this reading list correct, you're not going to get through it. So what I'm advising is you follow precisely what I'm saying here. Now, the first reading list 01, Mrs. Rustov, it seems it deals specifically with civil procedure and trial advocacy, regulation 79B. 79B. And that is the first one. That's actually the heading we're looking for, I personally think. So if we page through it, you'll see it deals with the Maynard versus Maynard case, ex parte application. There's a lot of court cases there. And under norms and standards, it would, for example, correlating to that, say the following. There is a substantial overlap in the uniform rules of court and magistrate court rules. We know that. We're busy with uniformity. Candidates must have a knowledge of the rules in both courts. The differences must be highlighted in particular the difference in powers or functions regarding the matches was scored. And so they give you the bottom line in terms of the reading list. All right. So let's go through it. They talk about disputes of fact in application proceedings. If you go to page 2, instituting applications, if you correlate it, they talk about case management, certification, trial preparation, contingency litigation. And I also want to say, now that I'm reading it, the bells are going off in my head, give due cognizance to contingency litigation. That's important to me, all right. So institution applications, then urgent applications, and they tell you all these things on the side. So make the correlation. Don't be intimidated if there's no correlations, because I've seen in this reading list that happens also, all right? Then you just read what you have to read, okay? So if I go to page 3 very quickly, answering and replying affidavits, additional affidavits. Now, why am I going through this in detail with you? The exam paper is coming out of the reading list, all right? This 5 reading list I'm doing now. All the other work is also in here. That will make you confident not to swallow a bubble when you get into the exam, or burp a bubble. I had to say that, my apologies. It just sounded funny. In any event, so that is what that's all about. This I'm doing now is in an exam. But everything we've given you in the sources and the pupil guide is in here. All right. So you've got the additional affidavits, discovery and notion proceedings, objections to processes of pleadings, participation by other parties. After pleadings close, what do you do? What happens in the orders, the prayers, the costs, particular kinds of applications, and eviction applications. Please take note of eviction applications. I did test you on one. You have to do a full one for me. And then summary judgment, and it goes on to applications for an Anton Pillar, search and seizure orders, interpleaders, and reading list 1 ends with International Bar Association Cybersecurity Guidelines, published in October 2018. Strange enough, when I went to look for this, I couldn't find it. So maybe you'll be more lucky than me. I used this address they gave. I couldn't gain access. So, but you're going to have to read it, because there can be exam questions out of this. Now, I don't care who says what to you. I'm telling you, if you have such a problem where there is a website or anything on this reading list and you cannot access it, you send it through here to the administration division so they can query it with the LPC, because the LPC has issued this. Because if you can't gain access to this and there's a question out of this, you have a problem. And this is what the LPC said in the LPC notice. They said this is the guidelines. So please, I try to get in there. Maybe we had poor internet. I don't know. Just make certain that you can do that. And then that was reading list 01. And I think the heading I'm going to run with here. Yeah, now I'm rather going to pass this on to Mrs. Rustov. And I have numbered it. She can keep what I've done here. Maybe later give it back to me, because when I did your multi-choice assignments, I actually marked where it came from to a certain degree. And I think she's going to have to need it if she wants to look at those things with a more in-depth eye. So this is the first one I've spoken about. Now there it goes to her. She's just sitting here on my side. I think she's pulling faces at me if I don't look. Reading list number 2. And yes, it might be different. This one says published in Government Gazette 4. That will be the same under section 3G1. Mrs. Rustov, that does differ, eh? 3G1. Okay, now we have it. So it's going to work out for you. The way I'm talking, it will be in sequence. This is very important to me. I mustn't muck around with you. I want every one of you to succeed and become a very productive and ethical advocate. Right, the same thing here. I'm just going to go through with it, because it's all the better than listening than reading. Again, do the correlation. Here they again throw out Erasmus. They again throw out Jones and Buckle. They again throw out Owen Rogers. And then again, they are looking at, in general, the character of action proceedings, owners, jurisdiction, the pleadings phase of actions. That's very important. They talk about a summons, pleadings, joinders, consolidation of actions, competent responses to particulars of claim. And they go on to further pleadings. Again, they merge into preparation for trial, further particulars of trial, different kinds of discovery, and they go over to special pre-trial procedures, a lot of court cases in between that you have to read, a lot of rules you have to read, a lot of sections you have to read, a lot of regulations you have to read. Then they go into conduct of civil trials, trial procedure, continuing a trial, cost and interest. On page 4 of this one, paragraph 5.4. Paragraph 5.4, it says interest, and then it says section 1, and then again 1, and then 2A. I'm advising you that a second one, I suppose, must be a 2, because 2 is before 2A of the Prescribed Rate of Interest Act number 55 of 1975. This is one of the mistakes I picked up. That cannot be 1, because then they're saying it twice. So please just have a look at that. They go on to appeals. On page 5, they roll out the law of evidence, and look at this. They are using the book, most probably all of you had. I believe you have to have it for your LLB degree, and that is Zeffert and Phases. Zeffert and Phases. So please, when I talk about Zeffert and Phases, you all know it's this fig. That's the biggest book, one of the biggest books you can actually have. So be careful not to read the whole book. Look at what I'm doing here on page 5 and go and have a look at what you should read. Then they're going to alternative dispute resolution, still at number 2. Principal works, they say you have to read Grogan and Ramsden Mackenzie. Then they give you an introduction that deals with distinctions between adversarial proceedings and facilitative consensus building processes, court annex mediation processes. Aha, Rule 14, capital A. That pause was to be dramatic. You need to know this rule. Arbitration agreements important. Domestic Arbitration Act, role of chairpersons, and all of those things. And that finalizes for me reading list 02. I'm giving it now to Mrs. Rustov. Then I'm going over to reading list 03. Oh yeah, we're in good hands now. I see now, yes, well, yeah, all right. Luckily I've marked them. Okay, I'm only going to go through this because I see also that I think it differs on the norms and standards. Here, they are changing from Erasmus. Now they say the reading list is Criminal Procedure Act 51 of 1977, and I've laid a lot of emphasis on your multi-choice here. And the Constitution of the Republic, very important. And then you must read the TWE, very well known, right? You had it in university, the TWE et al. Commentary on the Principal Procedure Act. And then again, they start general, the right to legal representation, arrest, bail, criminal trial, indictments and charges. And then that very well-known Shabalala case, make certain you know that case very well. They talk about joinder, splitting of charges, particulars of offense, pleas, exceptional pleas, and so on. The conduct of a trial, this is all criminal. Entrapment, admission and confessions, unlawful obtained evidence, conclusion of a trial. Unlawful of obtained evidence is very interesting. They're going to teach you about hearsay evidence also in civil and criminal. Interesting thing is, recently we won a very big case in Cape Town, actually about a month ago. It's been a case we had for 5 years. And everybody said, but you made submissions in your, not submissions, on your affidavit, you had hearsay. And I said, yes, but it's allowable. So within the discretion of the court, and there's a few requirements, everybody argued with me. And at the end of the day, the judge that did the case totally agreed, because it's in your books. They're going to teach you here. Hearsay evidence can be allowable. The discretion of a court can handle that. There's certain requirements, but the discretion of the court is paramount. Conclusion of the trial, competent verdicts, and then they go to sentencing. Sentencing is very important. One of the things I've seen in sentencing is a question that is posed is, can I put up any fine? Go and look here. There's court cases here that says no. Recent court cases say, hey, you can just put up any fine. If the statute says that's the fine, that's the fine. Don't have discretion to ask you 10,000 Rand fine if I must only ask you 1,000 Rand. There's a court case on it, and I did ask a question on it. Types of sentences, appeals and the reviews. Always remember the difference between an appeal and a review. I'm not going to get into that. The admissibility and the admissibility and inadmissibility of relevant evidence. There I talk about hearsay evidence. The parole evidence rule always comes up. Similar facts evidence, character evidence, very dangerous. Adjudicators must be very dangerous to look at the character of the people and make a deduction from it. It's not to say it's always correct. Opinion evidence, that is expert evidence. And so interesting. Have you seen the new trend in America? And I totally agree with it. They say to identify a person on his bite mark on a body at a murder or a rape case, actually they're going to destroy. That is not good evidence. You can destroy that in a court case. They say, or the identical. What do you call it, Mrs. Rustov? What is that English term? All right, she doesn't want to answer me. So actually, that's not reliable. It's not like fingerprints or DNA. Somebody bites you, it's easy to take any similar size moldings and shift it around and say, ah, here he is. It's unbelievable. Go and look at the Innocent Association in America, and they are working hard to get courts not to use that as reliable evidence in criminal cases anymore, because a lot of people in the olden days when it was used went to jail, and after when DNA became paramount, DNA are proving that it wasn't them, it was somebody else, and they're actually finding those people, and this guy's already been there in jail for 55 years for something he didn't do. So that was new for me. I looked at that last night. Not that you would know what last night means, because I don't know when you're seeing this. And that's interesting. That's interesting in criminal cases. You might want to look at that. Previous consistent statements, evidence, confirmation or cautionary rules, presumptions. Presumptions, very dangerous. Go and look what the Constitution says. The best one for me, because I was a police officer years ago, was the presumption that you have a certain gram of cannabis, you're a dealer. Constitutional Court says, yeah, no, that can never be. And I agree with them. Documentary evidence, mental capacity, and accused persons, and they end off there with legislation, the Constitution, evidence, and so on. So that is 03. That is then 03, and Mrs. Rustov will then make certain that they are in sequence to line up with the way I am rolling them out of here. Thank you very much. Then we're going to 04. There's only 5. We're getting to the end of this. And I'm trying to go through everything with you. Again, the reading list. See what you must read in correlation. If there's no correlation, then you have to read the whole thing. When you read a court case, see if they say specific paragraphs at the end. Then you read the paragraphs a little bit around it, and that's it. If they say, don't say, they want you to read the whole court case, all right? And if you can find the summary of the court case, that's also good, because usually that will have the most important aspects in that summary. Okay, number 4. Here they say your reading list is the following. Legal Practice Act. So when you do your guide and you come to this, it will be easy. It will be easy because there we really go into it. The South African Legal Practice Council Code of Conduct in terms of section 36(1). I asked you a lot of multi-choice questions on that. Universal ethical principles. Now this whole reading list 04, they want you to look at ethical principles, code of conduct, honesty, trustworthiness, loyalty, respect for others, adherence to the law, doing good and avoiding harm to others. Hello, that's a good one. And accountability. I'm going to read the other one again, just to feel good about myself. Doing good and avoiding harm to others. All right? You can never fabricate evidence. You can never be a crooked legal practitioner because you're doing harm to other people. And like I said in America, a lot of people go to jail and they are not the perpetrators. All right, so let's have a look at it quickly. Council's essential ethic duties are ameliorated. They are looking at that. They give you this big reading list. Council's duty to clients is an important one there. The referral rule. Rules governing consultations, witnesses, and cross-examination. Cross-examination is fun. If you pick up that skill, in the beginning you're going to struggle. You've got to get out there, you've got to do it. But, you know, I was a police officer years ago, so it's a little bit easier for me. I used to question the crooks, and before I know it, I've got him, I know what is, or I take him to the magistrate for a confession. So that's very important. Cross-examination, that is fun if you know how to do it. Get out there, go and do it. Be a tiger. Just don't insult. One day I was cross-examining a lady and it was a furious situation. It was a assault case. And I said to you, lying. I was in big trouble. Everything stopped. Called me into chambers, reprimanded me. You are insulting her. You cannot say that. You gotta use another way of saying it. And so you cannot insult. You cannot insult somebody on a cross-examination. I thought saying to you lied was quite correct. But very good, very good magistrate. He almost did a heart attack. I almost killed him. Rules governing consultations, witnesses, cross-examination. Are you listening to me? Are you listening to me? Being an advocate's fun. It's hard work, discipline, but it's fun. Surely you must hear that in my voice, in my demeanor. And then you will do fine. But you must realize your responsibilities are very, very big. All right. So, but I must say, I enjoyed my career very much. All right, they have got that Carolus versus Sambo bank case. There's a lot. I'm not reading court cases to you. There's a lot here. Interviewing witnesses during trial, cross-examination again, rules governing counsel fees, don't go to jail, stay out of trouble. That's what I'm saying. Pro bono and pro amico briefs. Ladies and gentlemen, you have no idea how many pro bono cases I've done. You're going to have to do them. But you cannot do too much. You must be careful of contingency. You cannot do too many cases of contingency because you've got to wait for payment. And if you lose, you don't get paid. Pro bono, the LPC can force you to do them, or you'll do it out of your own. So I just want to bring that to your attention. Now, a little bit of a joke, which is real. I've been paid with chickens. I've been paid with lasagna. I've been paid with chocolate cakes. And once I was paid with a bull and a cow. And that's for real, although it's funny. So yeah, one farmer couldn't pay me, and I had a farm, I had cattle, and he said, listen, I have a bull and a cow, and I said, oh, sure, drop it off, it's fine. And my wife still laughed at that. But I had a bull and a cow, and I had a farm, so what the heck, it worked for me. Cost the bonus to priest and other this. Now this, cost the bonus to priest. Go look at your new code of conduct. Advocates can get into trouble over this. Everybody is susceptible to disorder. If you're negligent, you're not doing your work. All right, so that goes court and professional etiquette, duty to obey the rules of the profession. Always have respect for your peers, even if they're rude and unpleasant. You take the ethical road. Many a times I was standing down there and I wanted to get up there and, you know, just sort things out the old way. But you must have respect. Don't abuse your peers verbally. We saw that in Cape Town. That counsel was defending the mafia. The way he spoke to that judge. Please. Unacceptable. I don't care what I have done. Once or twice I've lost my temper uncontrollably. And I slam on the podium and I say, I want a German too. I want to see the magistrate now in his chambers. Now. I've done it once or twice. And I get into the chambers. It's all so nice suddenly. So you can do that. But don't embarrass your peers. Even if you are behind closed doors in the chambers with him in his office, then please. I never jumped over a desk and grabbed anybody, but you feel that sometimes. Don't do it. You're an advocate. Not to say an attorney can do it, but please don't do that. It's the wrong thing to do. All right, access to the Constitutional Court, Bill of Rights. Bill of Rights, yes. I'm going to be drafting something on that shortly. But I don't think it's going to be in time for you guys to help you. So you've got to go through that. Constitutional remedies, specific procedures, declarations on validity. Those things are important. And on page 7, court cases, unbelievable. Then the principal works on page 8. We are busy with number 4. We're getting close to the end of this now. Justin Slapu, you all know him in Cape Town. Historical approach to customary law. Customary law is nowadays on the forefront. It's becoming important and a lot has been said about it. And you also know what the Constitution says. If it's not in conflict with any act on the Constitution, then it must be allowed. A lot of things are happening there. That is the guide that's being prepared this week. And we'll have it for you ready. All right, conflicts between common law and customary law, very important. Conflict of laws between customary and law systems, customary law institutions, specific customary law issues. Ownership of property is becoming a very sensitive issue in South Africa. I ask you a lot of questions on the communal land tenure bill. Communal land tenure bill. What a minister can do or not. I ask you a lot of questions and assignments on that. You better go and read up on that. And then the last one on 04 is traditional leadership, status, power, and administration. This is 04, and I'm going to now go to 05, bringing us basically to the end of this specific presentation. And I think what I'm going to do is I'm going to allow my voice to rest. And I think I'm going to come back on Thursday. Not that that would mean anything to you, I'm just setting Mrs. Rustov up here for what's about to happen. Right, the last one is then, of course, legal writing and drafting, Regulation 79G, open book. Legal writing and drafting, Regulation 79G, open book. All right, there you have that. That's going to be an open book. And there they're going to be looking at the following. Drafting, I just want to spend time with you here because this is the thinnest one. And this can flunk you, and it can be the most marks. But if you know what you're doing with drafting, examiners can easily give marks. Easily. Can easily help you. Except if you're totally wrong, you don't know what the heck you're doing. The drafting legal documents, pleadings and motions, content, managing fact, how to obtain relevant facts, that will be taking instructions. What are the sources of the fact? That's rules, regulations, common law, whatever. Obtaining documents, including electronic documents, how to preserve documents. How do you present an affidavit proving that there was no contamination of electronic data? That's the one there. Obtaining witness statements, carrying out in local inspections if necessary, how to record the evidence, how to obtain and preserve relevant exhibits, what exhibits are, the explanation above is required before any papers are drafted. Then analyzing the facts, working out the case concept, working out the course of action of the defense, deciding what procedure to use, action application, and remember, let's go back. Working out a course of action or defense, you cannot lie for your clients. Do you understand? It seems that today's advocates and attorneys think they can lie for their clients. Fabricate a defense. A defense must be derived from out of the facts, the opposing facts, the state's case. But you cannot lie. You cannot do that. You can only fight on the ethical foundation. There's no other way. Drafting of pleadings. That's going to be important. Give special attention to rules 18 and 22 of the uniform rules. Special attention to rules 18 and 22 of the uniform rules. All right. Okay, you want to know the uniform rules are the Supreme Court Act, not the Superior Court Act. Well, not an act, but the rules derived from the act. All right, that's important then. And then drafting notice of motion and 3 sets of affidavits. Did I tell you what they're going to ask you? Advanced drafting course. Candidates are expected to draft particulars of a claim, a contract, and delict. Don't worry, I tested you on that. So we are testing you for the exam. In the assignments, candidates must receive practical training in the following skills. Here we go. Everybody listen up. I'm going to read this. Let's see, is it a lot? I'm going to read this. Candidates must receive training in the following disciplines. How to obtain the facts and documents, how to sequence the facts and documents, how to extenualize the matter in law, where to find the applicable law, so you need to know legal research, how to apply the law and the facts of the case, how to work out the course of action or defense. I'm also going to read drafting skills, but that's a big money points there. With the use of case studies, candidates must draft the following. Be able to write down the material facts of a case, that's a summary. Be able to recognize the material evidence of the course of action or defense. Be able to use this to prepare a rough draft of the particulars of claim. You'll get it. You'll get a POC. Draft particulars claim with reference to the uniform rules and practice directives. Okay. Guys, you must know how to deal with practice directives, where you can find it and how to interpret them. That's the big bosses of the courts, how they want the courts run. But the most recent practice directives that is the most severe, and I'm helping you here, Rule 14, capital A, as well as case flow management. Case flow management. Know, make certain that you know what those directives in the Supreme Court are saying. All right, that's an important one for me. Draft particulars of claim with reference to the particular facts of the case. That's fine. That's fine. Be able to draft a version setting out defense to the plaintiff's claim. What is a defense to the plaintiff's claim? At paragraph. All those at paragraphs. Admit, deny, not a bare denial, note, all those things. Candidates must be introduced into drafting statements of claim and statements of defense, and then it goes to motion court, and it also does the first day. And then, don't be catch off guard because we're advocates. You must know how to draft heads of argument. I will not be surprised if you are tested on this because advocates struggle with this because they not really teach how to do this. And here on the heads of arguments, they say, candidates must be familiar with the layout and method of drafting different types of heads of arguments. Concise heads, comprehensive heads, main heads of argument, and written argument. There's different ones. Now, when you go to our sources, make a note there if you're listening to me. If you go to our sources, you will find there that we have included that into the High Court and the Magistrates Court practice. We actually show you the difference. We did that last year. And I did it as a moderator because the drafters didn't do it. So I know it's in there. The following must be in this module. The typical layout of heads of argument, the method used in applications, the method used in trials, the method used in appeals and reviews. Candidate must know how to draft chronological documents to be filed with heads of argument. You need to draft chronological and all things. POC, application procedures, contracts, legal opinions. We are all about order and not chaos. I hate it when I get a document and it's all over the place. You must always, before you work out anything, work out the structure chronologically. I used to do it in the beginning 2-3 years, and later on it became part of me, and then I didn't have to actually do it anymore because it became just an automatic way of doing things. But as a new advocate, you must work out. I had a big white notice board. Contracts, everything, I would say, number one, this is what I want. And then I would work out chronologically the flow of it. Nowadays, I don't have to do that. All right, so that's important. And then it goes on, then it ends with writing of opinions. All right, guys, I am testing you on writing of opinions. You'll see it in there, and you'll see what you can do for me on the facts we have presented. This is Reading List 05. And I'm handing it to Mrs. Rustov, sitting at my right-hand side. Shoo! That was a mouthful, I suppose, for me, and an earful, I suppose, for you. All right, guys, thank you very much for enrolling in this program. Make certain that you look at the introduction, at this overview, and then also at a code of conduct first, the one I'm going to bring on code of conduct, while you're busy with your reading. So this is the first time I'm actually saying it, but if you haven't looked at the introduction, go back, do it. This one is the second one, and code of conduct, I'll be back tomorrow or the day after to do that. And then you go to the audio clips in the sources material, all right, and work for all of that. And then take note, I'm saying again, advanced contracts. We have an old one that I did, but I'm going to do a new one in the future next week from the date I'm talking now. And then you'll have that one. You can listen to what I'm saying there. And now that I know that that one next week is going to be used for you guys, I will also spend a little bit more time on the basic structure of a contract, because I believe in my heart, if I teach you one thing on contracts, you'll never have it wrong ever again. I tell you, that's just the way it is. So that's that. Okay, guys, well, good luck and have fun with this. I hope that some of my energy can roll out into you guys in terms of making a success of this. Like I said, I'm very optimistic. I'm very happy I made this change in my life. The first 2 years I was very concerned. I did it from a faith foundation. I don't know how you're going to do it, but you have to work hard, bring in your clients. And if you follow this program, I personally think that you will also have a much better chance of passing the admission exam in September. Please send in every single assignment we're giving you to do. And I will be seeing you. I will definitely be seeing you. Maybe not all the time, but I will definitely be seeing you. And that's not to make your corrections. You must not misunderstand this. You're becoming an advocate. So we are doing what is required from advocates. We're putting you through the difficult stage of it. You can bounce things off me and I'll give you my opinion, but I'm not there to say, oh, you didn't get a mark for this. Maybe it's worth a half a mark. I'm there to assist you, to hear what you've done, and if you think that your way is also better, and to guide you psychologically and theoretically and practically a little bit forward. But this is not a relationship where I'm standing with a red pen behind you. You're becoming an advocate. If you can't hack it, go do something else. But I believe if you are listening to me, you've already made your decision, and from this side, we will do everything possible to get you to where you need to be going. Okay, guys, I'm out of here. enjoy and be blessed and turn everything negative into a positive always, and good luck. There we go. I'm going to push stop recording and I'll see you at the next clip.